Thank you, Chairman Graham. Thank you, Judge Brasher. Judge, you defended Alabama's legislative redistricting following the 2010 census. The United States Supreme Court found the state relied heavily on race when drawing district boundaries and on remand to Judge Pryor, for whom you clerked. The judge authored an opinion finding that 12 of the districts that were part of your defense were unconstitutional, racially motivated gerrymanders. Was the court correct in determining that Alabama's heavy reliance on race in redistricting was unconstitutional?
So, Senator, in the 2010 redistricting, the state of Alabama passed a new redistricting plan. It was covered by Section 5 of the Voting Rights Act at the time, and that plan was submitted to the United States Department of Justice to be evaluated under Section 5 of the Voting Rights Act. And the Justice Department, under Attorney General Holder, approved that plan under Section 5 of the Voting Rights Act, finding that it did not discriminate against racial minorities. As you pointed out, the Supreme Court entertained an argument that actually Alabama worked so hard to comply with the Section 5 of the Voting Rights Act that it had gone too much on the other side and actually racially gerrymandered. When that case came back down to the lower court, we litigated that case. It's one of the interesting things I've had over the course of my career is there are not too many people who have argued in front of a 3-judge district court, and I am one of them. And the court did find that specific districts were racially gerrymandered. After that finding, I actually worked with the legislators who drew those districts to redraw them in a way that comported with the court's decision. And after those redrawn districts were submitted to the court, the plaintiffs dropped their claims and agreed that they were now constitutional.
You've acknowledged Alabama has a history of racially motivated efforts designed to disenfranchise African Americans in Shelby County versus Holder. You argued Alabama had overcome those challenges. But since that decision, which removed the preclearance process, states across the country have imposed new voting restrictions, many of which have been held to be discriminatory by federal courts. Can you give an example of a discriminatory voting restriction that's been instituted after Shelby County?
Senator, I was a deputy solicitor general at the time that brief was filed, and that brief did acknowledge Alabama's shameful history in voting discrimination. Actually, I think that brief suggested correctly that Alabama was the reason that Section 5 of the Voting Rights Act was passed. Now, that brief argued exclusively that Section 4 of the Voting Rights Act, which provides the coverage formula for Section 5, because Section 5 doesn't cover every state. It only covered a few states as identified in the coverage formula in Section 4, and the argument that the state made in that brief was that that coverage formula needed to be updated in a way that was more consistent with the current facts on the ground.
Can you give an example of a discriminatory voting restriction instituted after Shelby County?
Senator, I have not researched that issue. I've not researched the issue of voting law changes after Shelby County versus Holder.
What do you see as the most important voting rights decision in either Alabama or 11th Circuit history, recent history?
You know, I think there are so many important decisions in that area. I mean, the Supreme Court has said, well, I don't think I really can, honestly. There are so many important decisions in that area that come from the state of Alabama, as you have recognized. I mean, the Supreme Court has recognized that we have a fundamental right to vote, and one reason why the right to vote is fundamental is because at the root of it, it protects our other rights. And the Supreme Court recognized that in cases, I think, that did come from the
Judge, I agree with you that it is our most foundational right in a democracy. Could you please just name one case for me from the 11th Circuit or Alabama that's an important voting rights decision? Just name one. Just name one for me.
You just want me to name a case?
Yeah, just tell me any case that you think was significant in 11th Circuit history on voting rights.
Well, at the time that these issues were being litigated, Alabama was under the Fifth Circuit. But you mentioned several cases that Judge Frank Johnson worked on. So, for example, he ruled in Gamillion v. Lightfoot about racial gerrymandering in a specific district, a specific city in Alabama. And so that would certainly be an important voting rights decision from the state. I believe that was a Fifth Circuit decision, however, because Alabama was under the Fifth Circuit and not the 11th at the time.
Thank you, Judge. We'll have more to talk about.
All right.
Thank you.